Hey, everybody, welcome to week 259. If you're not on vacation, if you are on vacation, I hope you're having fun and you're watching this on YouTube. And if you are not on vacation, or if you are on vacation, I hope you're watching it on YouTube and having fun. And if you are still here, thank you. We appreciate you. Um, as you guys know, for 259 weeks, we're going to be giving you live Q&A, and you can stump the chumps. Three of us here. You can hit us with anything, and we'll do our best to answer it honestly and productively. And you can harass us on the chat if Papa Joe's on. He's pretty good at that. And anyway, so lots of stuff going on in the world. We figured what we would do is we would talk about, stuff about how to kind of keep your money and how would you scale your company? What are the things that are on your mind right now? What are the things that in tax moves you should be doing now? Because, hey, we're almost halfway through this year. Can you believe it? I mean, good grief. It's amazing. So anyway, protect, profit, and scale. That's our topic for today and this week. Next week, Adam will get a reprieve and he's going to go speak at a deal, which will be exciting for everybody. And so we're going to have some AI folks. I think we're going to do an AI 2.0 because AI at work versus, hey, AI can do these really crazy things. Big deal. I want to know how to use it and what do we actually do and what should we be doing besides using ChatGPT as our next Google. So, anyway, that's what we're going to do. So Will, thanks for saying that. He said last week was great. Yeah, I asked Chad Jenkins to see if he could join us again. I think he's traveling. He's in Toronto that day or whatever, but he goes, I think I've actually got something better. He's got two guys that are in a cohort with him that he feels like are even more advanced than he is in practical applications. So I'm going to actually talk with those guys this week. But that seems to be where we're leaning for next week. Yeah, because we could have kept going. There was a lot of interest in that one. So before we get into a little bit more on protect, profit, and scale, any thoughts, Jack or Adam, that you guys have from current events, what you're hearing from business owners out in the field, things that are of concern to them, etc.?
Um, you know, I don't know if you've been watching the news lately, Gary,
I
but it's
try to
been
avoid it as much as
yeah,
possible.
it's been shockingly devoid of discussion on the big beautiful bill. Um, so
Before, well, and you
the
mean
the
after Elon blew up and his head exploded about it, and
yeah,
now
no,
he's
that was
reprinted?
pretty fun to watch. So the I think the reality is you got three votes in the Senate that you have to keep intact. And it is one of those things where, you know, everything that everybody's saying is roughly true at some level. So this is just a refresher for everybody that's on, because the way somebody says stuff can get misconstrued. You know, all this really is an extension of the tax rates that we already have, um, for more years, and with a couple little added gifts thrown in, which are great. Primarily around fixing some mistakes that were made previously and up and bringing back some pretty good and favorable depreciation rules. So basically it's just an extent. There's no like big reform here. It's just for the most part, an extension of what we already have. That's true. So like when people say, "Oh my God, you know, we're gonna raise tax, this is a massive tax cut." It's like, I mean, really, it's really just it's not a tax cut. It's an extension of what we already have. So tax rates were set to increase on a lot of people, which, for our average client, would probably equate to about, anywhere between 30 and $60,000 a year. It's like, I don't know about you, Gary, but I'm not looking at, that. I wasn't exactly feeling
It's not
like,
in my
oh
budget.
man, I've got so much sitting in my bank account. They need the money way worse than I do. They should have
Yeah.
the money, So that's the tax piece. And, at the same time, it's true, that there's, while you cannot say definitively, Gary, that 100% of the existing budget deficit, or the same thing applied under the second Bush as well, while you can't say that there's a one-to-one correlation between the federal budget deficit and the tax rates we have, meaning we cut them, it's hard to argue the correlation because I reduced the amount that the government took in. I didn't change any spending. And I don't know. I mean,
Yeah.
there is some math there, but last time I checked on that, unless I was in a surplus and I brought in less, now I'm going to be neutral. But if in fact where I really was at was, you know, I'm in a deficit and now I'm going to bring in even less, all that really means is I'm in a bigger deficit. you know, Unless I've got massive spending cuts to couple with it, which I think was kind of Will's point. So like as a logically I understand the math, because it is just math. And at the same time, emotionally, meaning like I sure don't want to write a freaking check. I'm pissed. Yet at the same time, if I go back to, Adam betting his house, while he may not bet his house, he'd strongly consider it. I think when faced with, you know, we're going to let these things expire on a few principles, which would kind of be the Rand Paul position,
Yeah.
if you're following the debates, versus like we're just going to hold our nose and live to fight another day. I mean, I'm really just going to bet on the hold the nose because it just seems to be that, like, in other words, it'd be a shocking change of historical pattern to not have bluster, 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 bluster. Okay, Dave. So that's just I'm looking forward to the Real Housewives of Washington episodes that we're about to see coming up, which is my version of called watching the news. But at the end of the day, will they meet the 4th of July? Maybe, maybe not. But I don't see how this isn't going to pass, and in at least a pretty damn close to the format. In other words, they might like I could see him getting rid of the no tax on tips, because that's dumb, and getting rid of the no tax on overtime because that's dumb too. And say, oh, Jack, we were the responsible ones over here in the Senate. Those were stupid anyway, and really weren't, doing a whole lot in terms of adding to the deficit. So anyway, soapbox done.
All right. Well, that's good. Speaking of 4th of July, man, we're off that week. So just so you know ahead of time. But I did order some overalls that are red, white, and blue. I mean, they are hilarious and they're shorts. So I haven't had overalls since I was a senior in high school. That's when they were really cool again. But I couldn't help myself. But um, speaking of July, one of the things that we're talking about is like, all right, how do you scale and grow? Do put this on your calendar. And this is a shameless plug for a boot camp, which is why I'm wearing my USA. It kind of looks like Army. But there's a boot camp by Sandler. And I'm not doing this because there's not a dime in it for me, but it will change your world. I'm telling you, I went through it 6 years ago myself, 2 day deal, and I don't remember what the price is. It's not much, but 2 days, July 22nd and 23rd. And I have yet to have somebody that I said, hey, you ought to do that, that came back and said, what are you thinking? They usually signed up for more. So anyway, July 22nd, 23rd. If you want more information, let me know and I'll get you connected with Jim Dunn and those dudes. Um, so Joe Farrell, good to see you here, Papa Joe. How many waiters and waitresses actually declare their tips as income? Ooh, that's a math problem.
Yeah, I mean, the truth is like equivalent to the number of times you paid cash for a meal in a restaurant. I mean, the practical answer is that they do claim them simply because they don't have a choice based on the fact that the credit card records the tip and then they're not, the restaurateur isn't in the business of saying, oh, let's ignore all that, sir. So by default, they just get put in their paycheck, as someone who waited tables and someone who currently has kids who wait tables. So, so I'd say with the exception of cash tips, which are rare these days, they're getting declared. I think the bigger question is, hey, what about those guys at Autoville?
Ah,
Yeah,
yeah.
my son worked at Autobell last summer, so yes, very familiar with that. And would come wake up the next morning and there'd be wads literally of cash just sitting on the counter. And it was just interesting to see the generosity of varying people, but also with regard to tips that I know I have friends who will carry cash in their wallets or in their pockets specifically to give a cash tip because of leaving it up to the server as to whether or not he or she is going to report that or not. But and
Mhm.
also is judicious about it. Maybe for a younger college student, maybe being a little more generous than maybe otherwise, which, that's a personal preference. But so, and then speaking of July, they are still, meaning Congress is trying to push for a celebratory July 4th-ish date for bringing the big beautiful bill into existence formally. So we'll see if that happens. I also want to share a bit of good news that if you're ever traveling through North Charleston and have an interaction with the police department, some of you may have seen this on the news. It actually made national news that apparently Sunday morning, oh, and it has to be apparently in the middle of the night, so that because maybe the police officers were bored or what, but there was a not so hot pursuit as the North Charleston police chased a tractor excavator down a main highway for more than an hour
Oh
at the speed
God.
at an average adult walks. The chase reached speeds of up to 3 miles per hour early Sunday morning. And apparently, a few minutes later, they got a burglary call, and and he ran away a little bit. But this went on for over an hour. So, I might imagine. Oh, and then it also said here, wait, what is it? Okay, the excavator was going so slow that the police cruisers would have to briefly stop several times a minute to not pass the construction equipment. Um, I don't think I'd have enough patience unless I was really bored and just wanted to see a show and watch this thing drive across. But I probably would have parked my police car, got into the excavator, pulled the person out while my partner got on the excavator and shut and brought it to a stop to 0 miles per hour from 3 miles per hour. So anyway, sort of dumb crook news, but it made national news and it's down the road from us in North Charleston. So
That is
anyway,
hilarious. I
yes.
mean, that makes OJ Simpson look like he was, going lights out.
Yes. So anyway, all
So
right,
I
that's a substitute for my dad joke today.
that was pretty good. That was actually
Good.
funnier than your dad jokes. So
Oh, thanks.
I do have a question while you're taking a drink of water. So with regard to um, the legal question on protecting profiting and scaling, especially on protecting. Talking about, can you give us some just basic stuff on the right business structure for growth and liability protection, LLC versus S Corp and C Corp? And I know, Adam, you're going to want to chime in from a tax perspective on some of that stuff, but that's
Yeah.
a confusing thing for a lot of businesses and business owners all the time. They and we see it a lot of times where they were told by some attorney that may not have been asking about what's your end game, and then they put them into a structure, and then that structure doesn't serve them all that well from a tax perspective or even where they want to go.
Yeah, absolutely. And I also was thinking, Adam, that we may want to touch on 1202 and just in the context of, okay, the pros and cons of that, because Warren brought this up in a meeting. Keen, my tax partner, brought this up in a conversation yesterday where we were presenting to our summer interns as to what we do and how to drive business and that kind of thing. And Warren got up and said, well, if you tell a client that they can save millions of dollars on the growth of the business and not have to pay taxes on any of it, that kind of grabs their attention. So I think that might grab the audience's attention today. But taking a step back from that specific benefit, it is confusing, and it can be, because you really, when you're talking about entity formation, you're really talking about two aspects of it, which is the legal aspects and the tax aspects. And it used to be, before LLCs came about, that you really had only kind of two choices for the most part, which was be a corporation or be a partnership. And so LLCs came about to kind of get the best of both worlds, where you can become this thing, this entity that protects assets and keeps liabilities within the context of this artificial person in the form of an entity. But you also get the benefits of choose your adventure on a tax perspective. And what I mean by that is, when someone comes to us, and you said it, Gary, very succinctly, which is, what is your end game? And I think a lot of people don't think about that, or they don't have attorneys that guide them. I was in conversation with in-house counsel yesterday for a very large company, new in-house counsel, and he basically went to our mutual clients and said, what is your end game? And it was interesting because it was different for the four owners. They weren't on the same path. And so in him coming in and trying to put them further along their objectives, it was interesting because their objectives were a little bit different than they were previously when they were more aligned. And so that really is the first question. But then what you do is you have to move it forward. So the choice of entity, I would say that because Warren Keen has engraved this into all of our minds for many, many years now, that the LLC format is the champion choice of entity from a legal structure. And the reason being is this: corporate law was developed to be a lot of rules that are default rules that in some cases cannot be superseded. And so it was basically that, okay, you have to follow these rules, and then you can supplement these rules with bylaws, with a shareholders agreement, with buy sell, whatever you want to call that mechanism for the succession of the business. Then what happens is that you have the LLC, which came about, and it's derivative of partnership law. So where you have the possibility of like general partners and limited partners, but in a different format, and the ability to have less rules imposed upon you, whereas the rules in the LLC Act are really fallback provisions. And I tell clients that your operating agreement is the Bible for your business. And whenever you come to me and say, can we do this? Or are we prohibited from doing this? My first response is, what does the operating agreement say? And so you get to create more rules within the LLC environment. So then, as I said, it's derivative of partnership law. So does partnership tax apply to an LLC? And the default is, if it's multi-member, meaning two or more, the default is partnership tax law will be applied to that LLC. Imagine the scenario where, okay, I want the benefit of both worlds, legal and tax. So you have the ability to become an LLC, but then choose to be an S corporation. So for all the reasons you might want to be an S corp for tax purposes, which is in some cases to minimize your compensation of ordinary income and pay payroll tax, and then push some more of it to distributions to you at a lower tax rate potentially. And so things like that come about, you have the flexibility within the tax code to be able to do that. In some cases, you may want to be a C corporation. If you're dealing with, for example, foreign investment, and you want what is called a blocking entity between the foreign operations in Europe and the US operations. And so and we could talk for hours about those kind of things as well. So and a lot of times people get it wrong, attorneys get it wrong, and where a significant point of weakness in the armor is when you started out as a LLC, multi-unit, you were just doing partnership law because you hadn't even considered whether you wanted to be an S corp or not. At some point down the road, an attorney or your CPA says, hey, you should become an S corporation for these reasons. And then you do that, but you kind of forgot that there is this document out there that I just told you is the Bible for your business that has partnership tax law specifically in there. So it would have citations to Treasury regulations that govern and will walk you through what happens when money is brought in, when assets are acquired, when assets are sold, those kind of things. The financial relationship between the owners is set forth in the operating agreement. And so you have to essentially extract those provisions and put in ones that are more appropriate for an S corporation, including language that says no member, no owner will do anything to blow the S corp election with the IRS, and things like that. And so we get sometimes some operating agreements that come to us, and I find out that they've been taxed as an S corp, but I'm looking at language that would imply that they are taxed or should be taxed as a partnership because that's what's in the governance documents. So there are inconsistencies that come up like that. A lot of times those things aren't found until there is a reason to find them, which is a bank financing where they say, let's see your governance documents. Well, do you realize that there is this issue? Or an investor comes in or a buyer comes in and says, hey, that we have this issue and we want to make sure we as buyers are not going to get in the middle of this potential liability. So we want you to indemnify us for that. And we're going to hold back some money to fund that indemnification in case the IRS comes knocking at your door and says, why were you doing this way in error? So a long-winded way of saying that you have choices to make, and you should not take those decision points lightly, that you should consider your end game. You should consider your current game as to what you want to do, and not just say, well, okay, sounds like that, I heard that we should be an S corporation, even though we chose an LLC. And, can you do that? Can you file the S corp election, without any further discussion? And it really is incumbent upon the owners to have that conversation and share that. But really, your professional advisor should be attempting to extract that information from you. I also want to, now, since we're talking about governance documents, just documentation in general, another potential point of weakness or strength, depending on your perspective, is the memorialization of the things that you do. There are many times where I find clients who say, well, that's the way we've been doing it for 10 years. Okay, why? Well, that's just because how we started doing it, and that's how we've continued to do it. And by the way, yeah, 2 years ago, we kind of changed the way we did that. But we never kind of recorded that. It's just kind of the way it's been happening. And now the other side is coming to us and saying, this isn't working for us. And so we want to go back to the way we were doing it originally. And so who's going to win that argument? Who knows? I mean, and I could tell you, it depends on a lot of things, factual things that have happened. including the behavior of the parties. But the what doesn't change is the fact that you don't have a document that says what is supposed to be done, and what, and even worse would be is you had a document, you changed the way, the terms of that document, the way you were doing the business relationship, and then 2 years after the change, one of the parties comes back and says, yeah, I don't want to do it that way anymore. It's just not lucrative. Things have changed. The economy has changed. It's costing us more to do it this way. We want to implement this technology, and you're telling us we can't do that. Or I'm telling you that you are not permitted to impose that change on us anymore. We're going back to the original contract. So I would say that that is, kind of what I wanted to lead off with in this entire discussion, which is you should, even though, the days of ladies and gentlemen's arrangements, I shouldn't say has passed. I would say that it is used sparingly, and especially if you get lawyers involved. I have seen on occasion where parties have said, well, look, I know that isn't what the agreement says, but that's what we've been doing. Let's find a way to make this work for both of us, because we can't continue onward that way. So again, if from my perspective, from a purely legal perspective, when a client says interpret this stuff, and I'm like, okay, this is what it says, and it doesn't say the other, so you're either SOL or you force it the way it's written. So yes, Adam.
2 questions we always get asked, and you may have already addressed this, but should I be in Delaware? So if you could just address what that nonsense is about. And then secondly, is there, in the state of North Carolina, which is where most of our clients are situated, is there actually a difference in the law? Meaning, like, I got membership units for stock certificates and all that kind of stuff. But in terms of like crops going down, I'm going to get sued by somebody. Is there any real difference between being an LLC versus being a corporation in the state of North Carolina based on that scenario?
Two great questions, and totally unrehearsed, actually. So
yeah,
well
so
done.
I'll make sure that we're not recording this part for a post on the Shoemaker website.
No, that's fine. No, all good, all good. I won't give away all the secrets. Just
yeah, no,
a lot of them.
I get asked this all the time, and I'm like, this is like, it's not that it's a dumb question. It's just like, oh my God, like, I can't believe I don't know the answer. And at the same time, I can't believe that it's created so much confusion in other people.
Yeah. The Delaware thing, I get that all the time as well. And a lot of times you'll see that more so when, if you are selling and then you have the buyer entity that says, okay, it's the agreement is under Delaware law. The buyer is a Delaware entity. You guys have a lot of familiarity with that. And so it's, the reason being is, and this is a Jack theory, which I think is an actual theory, which is that Delaware law, first of all, the genesis of LLC law and the genesis of corporate law is Delaware. And Delaware has been kind of on the leading edge, cutting edge, bleeding edge of the evolution of business law, generally speaking. And what you will see is that Delaware kind of takes the first step in interpretation many times of the law. And so you have what is called the Model Act, and it was created by an organization that it was created to create a model rules on the corporate side, on the LLC side. And so you see, and that's the reason why you see, if you were to take the LLC Act from North Carolina and South Carolina, you're going to see a pattern, a similar pattern of provisions. Same thing with the North Carolina Business Act, South Carolina Business Act. I mean, the sequencing will be different. The numbers will be different. It's within their own statutory regime, but you'll see a very explicit pattern of language. And so what you will see is when there are changes that are made by the Delaware legislature and are implemented in Delaware, many times those things at a later date will be implemented in other states. Or where there is a provision that has been, even if it hasn't been modified or enhanced under Delaware law, but has been interpreted, if that interpretation is relevant to the interpretation of the North Carolina law, which is derivative or is similar to, then you'll see a lot of citations to Delaware, the Delaware courts, the Delaware case law that says, hey, this is how this should be interpreted, or this is how we've interpreted it. And so the argument is, and therefore the North Carolina court should interpret it similarly, and giving deference to the Delaware court. There's no requirement to do that. So what you will see is parties who, instead of wanting to have a North Carolina court, a Texas court, a Colorado court interpret and do that kind of two-step analysis, they will just form a Delaware entity and get the benefit of the Delaware law and the Delaware interpretations of that. And then, so if you form in Delaware, then you have to get a certificate of authority to operate in North Carolina. The reality is that the case law, unless it's a more sophisticated organization that, and you're dealing with a lot of moving pieces and the org chart looks humongous, essentially, you're not going to see a lot of smaller organizations, companies forming in Delaware, because there really just isn't a huge benefit to doing so. From a legal perspective, and I really don't think from a tax perspective either, but I wouldn't be able to speak directly on that, and I'm be way out of my lane for doing so. But that is the reason why choosing Delaware from a legal perspective, or why people choose Delaware. As far as differences between LLC law and corporate law, what you will see is now that LLC law has developed more so over the course of time since it was implemented. The last change to the North Carolina LLC Act was back in 2014, which, as you guys know, and maybe some of the people on the line know, Warren Keene was the chair of that committee. So basically, Warren Keene wrote the revisions to the LLC Act. He will never admit to that, but that's why when I have a question about the LLC Act, I walk 2 doors down and ask him. And I already know what the operating agreement says, because that it will be his first question is, well, young Jack, young attorney, what does it say? And I will tell him, and you go to him with interpretations of what the answer might be. So it's very professorial, which is fantastic. So I would say that if there is an issue that has not been maybe adjudicated under LLC laws, that there would be an infusion of Delaware. There would be a Delaware LLC, Delaware corporation, but also North Carolina corporation law interpretations that are infused into the interpretation of whatever the issue is under the North Carolina LLC Act. So you have those influences there, but I would say that if you were to compare a poorly drafted operating agreement versus being under the default of the North Carolina Business Act, you may be better off being in the North Carolina Business Act, because it will deal with more things that may be adversarial as between the owners and just the operation of the business. So what I'm saying is, you really need to have a good operating agreement in place to have the benefit of everything, of the law, of the relationship, the contractual relationship, the enforceability of the arrangement between you and your partners. And so and not to leave things to chance. I see a lot of, and I've always said, you use LegalZoom, you get what you pay for, which is a document with a bunch of blanks that really, and it just has to be that way. It has to be it has to have a common denominator, right? And so it can't be specifically tailored to the owners, the operations, the choices that owners will make with respect to succession planning. One of the things that we talk about, and I feel like I'm taking up a lot of time, but so the last point I will say is that succession planning within, do you want your beneficiaries to receive the benefit of and continue to receive the benefit of the business operations, or do you want them to cash out and get the cash and go on with their lives and be doing things that they want to with your legacy, essentially? So anyway, I'm very long-winded today. I'm sorry.
No, you're doing great, man.
Yeah,
You're answering the stuff, man. I appreciate it.
it's all important stuff. Before I piggyback and have you talk some more, Jack, I want Adam to address the note that we got from Papa Joe, which was about, hey, estimated taxes are due. It depends. Because if you're in South Carolina, that's one answer. And if you're in North Carolina, it's another answer. But we did have extensions to North Carolina based on the hurricane relief. If I'm not mistaken, we now have until September 25th for those payments. But other states are not included in that. Am I correct in that understanding, Adam?
That was for the first round of payments that were due. So we're still having people make their 615 estimates.
Okay. All right. 615 is coming.
Yep. Pay away. They need the money.
All right. So the next question, and Jack, the operating agreement thing is like a big freaking deal because nobody thinks it's going to be a big deal when everybody's singing Kumbaya and they don't have any money. They're like, hey, it's going to be great. We're never going to have any problems. But life changes, stuff changes, people change, priorities change. And now all of a sudden, especially 50-50 partnerships. Oh my goodness. That gets really tricky. So I just want to say yes and amen to what you said there. But here's a question for you, Jack. I've seen it work really, really well. And I've got a situation right now where it's not working because they didn't like. So let me give you this situation, and I really want your perspective. The situation was when we were negotiating on Savona Mill on our new location that we're going to be moving into, Lord willing, in August. Super cool. Early on, I told our real estate rep from Newmark, I said, listen, I want to get through this legal mess back and forth, and I want to minimize the redlining back and forth, because attorneys do what they were taught to do, redline. And can we do a powwow on the front end where we get the landlord, their attorneys, us and our attorneys, so that we actually have a meeting of the minds of adults to adults so that we can actually outline this is what we want to do, because we had an LOI, blah, 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 and now we need to formalize it. And they said, yeah. And it actually went incredibly well. And I remember Patrick saying, our rep from Newmark, going, man, that was the smoothest. Like, I've never seen anything go so smooth. And it really minimized all the fees on both sides. It was really great. Now we're in a situation, same folks, and we've got an internet provider that is different, that wants to do the ROE, and then the current one that's in there, but it's somebody that we're tied to. And legal counsel between the internet provider and the landlord's legal, it's a bloody mess. I mean, it's been going back and forth to where our internet provider has said, we're out. But we've got a 30-month contract with this internet provider. And now we're going to be paying huge additional fees because of this nonsense going back and forth. So I said, we need to get these people together. Now, from a legal perspective and like from a law firm perspective, when does it make sense to actually try to do a powwow where you have everybody, adults, versus the volley back and forth, and then you get to an impasse, which is actually where these two groups are right now. And I'm like, and we're the ones going to be paying and suffering for it if we don't get these guys to get past the log jam. I'm just curious from your perspective, Jack.
And I'm sure you can answer that. The initial answer, what the
It
answer is, right?
depends.
Yes, sir. Absolutely.
I've been with you a while.
And the reason why it depends is that a lot of it has to do with the personalities of the players. And some people are okay with in-person meetings. I tend to, as counsel, not really like to do that, but I know there are times I don't like to do that, is that if I have a okay, is everything okay? Because I just
Yeah, you had a couple cutouts with
okay.
probably some internet stability because
Yeah.
somebody knew that I was talking about internet providers.
Yeah, uh-huh. Um, so and the reason why I'm gonna get a little hesitant is because lawyers can be used to allow the parties to agree in concept, but then if they change their mind, they can say, well, my lawyer said that was a good idea in concept, but legally you can't do that kind of thing. But the benefit is that, so when you're negotiating terms and you're getting to an impasse, to put everybody in the same room so that there is an understanding that, okay, while I may want to be protective of my, let's say, landlord client, and I want to dump all of the common area maintenance fees possible into the common area maintenance fee provision paragraph. And I have reasons why I want to do that. And the tenant says, well, wait a minute, we don't think that that is equitable because you're charging, water, and we're surrounded by restaurants and we don't use as much water. So, and I had that, and the reason why that came to mind is because that actually happened recently. And so I was like, okay, because they weren't telling us what the problem was, like why, and they weren't specifically saying it was the water issue and not just electricity and everything else, that the way, and they said they wanted a separate meter for power. Okay, well, landlord will do that. That's fine. We'll have to do that for everybody. But we were already thinking about, like, the client was already thinking about doing that anyway, to be more equitable about the distribution of power costs in relation to the facility, which had grown at that point. So the and really, as long that works, as long as everybody's on the same page that this is a discussion, it's not binding. If someone says yes, or that sounds good, or that sounds okay, that doesn't mean yes, that is definitely going into the contract. And then, because what will happen is I hear a yes and I draft it a certain way, but they still have a problem with it. And then I go back and say, but you already said yes. So there have to be rules to the in-person meeting. But it is in the scenario where I try not to get involved too early, just simply because I think the business owner should have an open discussion about things. So then, drafting the LOI, but if there is an issue in interpreting the LOI into the definitive agreement, then into a lease or a purchase agreement or whatever it may be, then taking a pause and having that discussion would be appropriate and likely helpful. Again, as long as you have the right personalities. I will tell you that there have been cases where it was proposed that we have an in-person meeting, and me either knowing my own client's personality or the other side's personality, just based on the negotiations, and my deeming some of their points unreasonable, that there's no way that
Yeah,
it was going to be
yeah,
productive. And I'm not going to get in the same room and just waste my time doing that, because I don't want, and
yeah,
like I said, candidly, sometimes it's been my own client. I'm like, I know he will promise me to not say anything and not get upset, but it's just in his personality, it's in his blood, whatever it may be. And I know it's just at some point he's just gonna snap and he's just gonna go off. So there's not gonna happen, that kind of thing.
yeah.
So
Well, and that's where we did it. We did it after LOI into the formal agreement to make sure that we were all on the same page, because there were things that their attorneys interpreted differently from what we were saying. And that's where it got, things got kind of messed up. And it would have been ink wars going back and forth had we not done that. And unfortunately, that's what happened with this internet provider. And yeah, so hopefully we can get it back on the rails. Nick,
and Gary, one
yeah,
variation of that before you go on is that, you could maybe have 2 or 3 rounds of back and forth of red lines. And then that's when you take a pause and you either have the in-person meeting or you go to, let's talk about bullet points in an email
yeah,
back and forth, rather than, the entire 40-page lease back and forth. And I've done that
right.
too. And that way you get more succinct in the discussion and then you implement it in the document. So sorry.
Yeah, no, I appreciate that, because it is really frustrating being the person or the company paying the bills on both sides of the attorneys. And the attorneys are doing what they're supposed to do, which is defend and protect their clients. I get it. But it at times it feels like, wow, this is a game at my expense, like, and so, and that's where I think frustration mounts at times. I'm going to go back, where we talked about the 50-50 partnerships. So Nick says, um, uh, I guess 5149 is the answer. Yeah, but you wouldn't believe how many 50-50 partnerships, because they started as equals, and they wanted to maintain, and they were afraid of somebody taking advantage of it. And then they get into a loggerhead, and that's when it gets really crazy. Um, he did ask also, Nick, thanks for chiming in. Is water prepaid individual meters a solution, in your example?
Prepaid, probably not, because it's still, I would say that, well, I don't know if a landlord would agree to that, because what if you start using more water? I think it just should be based on usage. And if it's, sometimes pro rata based on square footage is not equitable. So that's why that
Hmm.
happens. I will also say on the 50-50 versus 51-49, as far as courts getting involved. So, there are 3 types of dissolution: voluntary, involuntary, which is the government says you didn't pay your taxes or you didn't provide your annual reports to the Secretary of State. And then there's judicial, where the judiciary gets involved pursuant to a petition to dissolve the company. I will tell you that courts, judges, juries are not particularly keen on helping you unwind a business arrangement where you have agreed to be 50-50, unless, and again, these are very general statements, unless there is an impact, a larger impact. So let's say that you have two 50-50 owners that are fighting. In the meantime, the business is bleeding money.
Right.
They're not sure if they're going to be in business longer. They employ a ton of people. And so there needs to be an intervention, whether it's to appoint a receiver to the business, or, some third party to be involved in the business. And so, but just keep that in mind, because some people have said to me, well, if we get ourselves in a bind, we'll just go ask a judge to figure it out. I'm like, that's a bad plan. Let's come up with a better plan. And I have some suggestions on how to do that.
Yeah, that's good. Um, yeah, Joe, I wish you could fix, Joseph, I wish you could fix this one. But I don't know, you know, if we could talk offline on that one. Uh,
Yeah,
so,
Adam, do you want to mention the 1202? Because it just seems to
yeah,
be coming up, and it may not be appropriate for everyone, but something to think about as you go down the road.
Yeah. So, um, if you own a C corporation, then you've got a couple ways that if you sell the company and you're the right kind of company, which basically is pretty much every company but a medical practice, a law firm, or an accounting firm, then you have the opportunity to exclude the gain from the sale, as long as the company has been around and in your possession for the preceding 5 years. There's some other little things that are in there that that you have to consider, but it does make the choice of entity formation a little bit more higher stakes. And nobody, this has been around for a while as a thing for people. Um, and I mean, look, if I have the opportunity to exclude $10 million of gain upon the sale of my company and not pay any taxes, wow, will pick up my ears, as Warren said. Um, but the thing is, nobody was really doing anything with it because, prior to the 2017 Tax Cuts and Jobs Act, to be a C corporation, you were going to pay a 35% tax rate than if you wanted to put the money in your grubby little pocket or your clean little pocket, whichever one of the case may be. You also had to pay a dividend tax on top of that, or you had to take all the money out as a W-2 paycheck, leave no money in the company, blah, 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 blah. So just C Corps weren't that popular, like you were just stuck with them. There weren't that many. But then 2017 Tax Cuts and Jobs Act comes around, and it's like, look, if I'm ultimately pushing for a liquidity event, and I'm growing, therefore I'm not distributing all the cash out to myself anyway, and I otherwise qualify, you really gotta take a look, at, hey, this is a real deal. I might want to consider this. Um, all of that said, hey, I'm already in existence. Can I become a C corporation now? The answer is yes. I mean, you can do some reformation work that will allow you to be a C corporation now, even if you've already been in existence, even if you're an LLC. But you got to do some work, restructuring work to really get it right, to make sure your I's are dotted and your T's are crossed. All of that said, if you're like, this is the greatest thing that ever happened to me, the other side of that equation is that you have to, when you go to sell the company, you have to find a buyer who would be interested in your stock, which does create a problem. Meaning, like most people that buy companies are interested in your company, but not interested in your dirty laundry. So they want to buy assets, and that means that 1202 and excluding the gain on your stock isn't really a thing because you didn't sell your stock, you sold the assets. So you just got to be, it kind of comes back to, hey, when you get that LOI, make sure you have somebody look at it to know what's going to happen. All that said, can that be a negotiating thing? Can you insure for it? Can you have some reps and warranties that help you out with it? Probably the other practical answer is operate really squeaky clean. Because chances are, if you sell to a big enough company, the end form is going to be a C corporation anyway that they're moving into, and they just don't want the dirty laundry. So somehow you got to do some fancy Jack style lawyering to make sure that the dirty laundry is cared for as part of the transaction process. So, at the same time, it's like, if part of the consideration, for example, is stock in a new corporation in exchange for your stock that you had, there's already some revenue pronouncements out there that say that you can go ahead and use the TAC period, originally and still qualify. So there's lots of good stuff in there, but it's suddenly not, what I am is suddenly not such an autopilot thing anymore as it used to be. All that said, if I'm two guys in a prayer bootstrapping it, maybe I'll sell, maybe I won't, and I need the cash to live, is it a consideration? Yeah, but it's going to be a little bit lower priority out there than it is than just, getting the cash out tax efficiently. Whereas, hey, I'm, well capitalized, don't need to take the cash out, aggressive growth plans, or like, high intellectual property environment where a C corporation probably is going to be the ultimate exit anyway. Yeah, I strongly want to consider it. And Papa Joe, I had a chance to see your son in his new place a little while back. Said he was going to have a nice Father's Day host for you. So I hope that's still happening, and have a good time down there.
Yeah, Father's Day is this weekend. Hey, how about that? Happy Father's Day to all the dads out there. And if you have a dad that's still living, make sure you tell him you love him. It's a blessing to still have a dad that's around. So, well, as we're coming up to the top of the hour, any final thoughts?
I'll just add one thing on to the 5 years tends to also be dissuasive, and I think more so now than maybe only a few months ago, even with tariffs and everything else. So things that impact the business that and certainly the whole COVID thing, so being able to sustain the business over adverse situations over the course of 60 months sometimes is a bit difficult for people to accept or take the risk of that. So as Adam was saying, it just kind of has to be, at least you see a higher, more perfect vision of the business and being able to sustain the business through bad times, I think, is also an important consideration in dealing with that. But yeah, the benefits of being able to exclude $10 million, zero taxes after 5 years, if you do it right, is appealing to many that have built up their business and know that they are going to be in business for 5 more years. And so people don't know about it. And and so it's one of those things, well, okay, is it time to transform into a C corp? But there are rules related to that, and also the double taxation, everything else. So it needs to be a really thoughtful economic analysis before you jump into that.
Papa Joe says Chinese tariffs are going away. Well, at least for 90 days from what we're seeing, right? It's like, who knows how long. Recheck those furniture prices on that new office. You better believe I'm going to do that. It's too late on the steel piping that we had for electrical and all that kind of stuff, because it was paid, had to get it done. But we got sheetrock up. They're painting next week. So I'm pretty excited. So, hey, got a question that came in. To avoid 10 million on sale of the company, does the past history count toward the 5 years? Nope.
Well, Jack shaking his head. There's a yes and a no. And like, I hate being a Jack and saying it depends.
Depends.
There is a way, but it's highly complicated and beyond the scope of the 1 minute left remaining here. So you're kind of better off just saying, okay, let me do it right now, because even if you do it right now, then you've got a better shot at the retroactive fit from the tax period. So because it is going to involve some conversion stuff. So
that wasn't an it depends answer. Just saying.
Yeah, no, I did a great job with that. Thank you, Jeff.
Yeah, huh?
I learned from the master.
Yeah, if I remember right, Adam has worked some magic in that realm before.
Yeah.
It's one of the reasons why we love you, Adam. So again, wishing everybody happy Father's Day a little bit early. Thank you guys for taking the time to be on. Next week, we'll plan on going to do another deep dive on AI at work, and while Adam's speaking at his event. So anyway, you guys have a great rest of the day. Stay cool and hydrated out there. See y'all.
Thank you guys. Happy Father's Day.
All right. See ya.
Bye-bye.
Bye.